Good morning, participants. The Center for Exceptional Families wishes to extend their appreciation for your attendance today. We have Mr. Oliver Dillingham, Program Manager, Lasagna Johnson, Program Advisor. They will be presenting the Section 504 Access Protected. They are with the Equity Assistance Center, Legal Services with the Arkansas Department of Ed. And they have also brought with them today Lance Levere, also a program advisor. We thank you guys for presenting for us today. And participants, your mics and videos are off. However, we will be accepting questions. And so if you will type them in the Q&A box or the chat box, we greatly appreciate it. Ms. Lasagna or Mr. Oliver, it's all yours.
Thank you. Thank you so much. Can everyone hear me all right?
Mm-hmm.
All right. Well, as you stated, my name is Lasagna Johnson, and I am a program advisor here with the Equity Assistance Center, and we appreciate you all having us. Today, we're going to be looking at Section 504 and how it protects student access. So since 1985, the Equity Assistance Center has had the responsibility of assisting school systems in the state of Arkansas. So by helping them identify gaps in fairness and in their compliance with regulations that prohibit discrimination. Regulations such as Section 504 of the Rehabilitation Act of 1973. So fairness means that students get what they need to have access to educational opportunities. The provision of services under Section 504 is one way to make sure that students in Arkansas are achieving fairness. Listed here are some of the items to be covered today. We're going to discuss the statute itself, as well as how it relates to Section 504 meetings, 504 plans, and due process. Then Mr. Dillingham will discuss the roles of the parent and the school district in this whole process. So Section 504 is a federal civil rights protection law. It prohibits discrimination based on disability. Section 504 applies to any program or activity that receives federal financial assistance. And as we go through this presentation, we're going to see quotes quite often either directly from the statute or directly from the Office for Civil Rights or directly from some frequently asked questions for the Office of Civil Rights or their guide. And so whenever we have a quote at the bottom on the left-hand corner, we'll see where that quote is coming from. And there is a link, and when we're able to share this out, anyone can click on that link and find the context of where that quote is coming from to read the whole paragraph or to read that whole section of the guide. So the initial intent of Section 504 back in 1973 was to prohibit disability-based discrimination in employment and federally funded areas like airports and libraries. But over time, it began to apply to education. So now it ensures that students are provided equal access to benefits and to the education comparable in quality to that of students without disabilities. So it requires that students have a free and appropriate public education, and the acronym for free and appropriate public education is known as FAPE. So the big takeaway, and there are a few in this presentation, you're going to be presented with a lot of information, but I do want to make sure as we go through that I point out the big takeaways. And so for Section 504, one big takeaway that its basis is that it's comparable in quality to the students without disabilities. So it's not necessarily focused on making sure that the individualized student achieves their most optimum potential, although that's important. There are laws for that. But this basis of Section 504 is make sure that their access is the same access as students without disabilities, and that it's equitable, and that in order to be fair, they're giving supports and services to make sure that they're receiving the same quality education as all students in the school. So to gain access to FAPE under this statute, students must meet the definition of disability in Section 504. And so that's what we see here. The criteria is they must have a mental or a physical impairment that substantially limits a major life activity. So there's a lot of information in that definition that we're going to pull out. So when determining the existence of a substantial limitation, because the word substantial can be interpreted by different people in different ways, but the way that the guidance that they provided is the student can be compared to the peers without a disability to kind of determine if there is a substantial limitation. So by looking at the peers in their same grade level to see what the difference is between those two individuals. And then also a major life activity, they define that as well. Within the statute, they have varying examples, but it's not just related to learning, which is a major life function as well, but it can be related to hearing, it can be related to breathing or speaking or being able to process or any other life functions. So here's another big takeaway is that the definition itself is very important. In order to be served under Section 504, the team has to make the determination that the student meets this definition. So a formal written medical diagnosis is neither required nor does it constitute automatic eligibility for services under Section 504. So having a medical diagnosis doesn't necessarily make it automatic that you will be served, nor is it required that you have to have that to be served. But if the team determines that a medical evaluation is needed, that they need a medical diagnosis to make sure that they're providing supports to the student, then the school district could provide that at no cost to the parent if the team deems that they need that. But also in the same thinking, a student does not have to be in a grade in order to be protected under Section 504 or to get a Section 504 plan. They don't have to have poor student grades or poor attendance or poor behavior. Those things are all indicators that a disability might be present, but they're not explicit requirements that those be present. Because we know that some indicators of a disability are hidden. So the requirements to be served under Section 504 is to meet this definition and the team coming to an understanding that the student meets that definition. And that's a big takeaway as well, is remembering the definition of Section 504 regards a student with disability. So each school district or charter has this affirmative duty to locate students with disabilities. And this is in the statute, to undertake and identify and locate students with disabilities in their jurisdiction or in their zone. That is their duty. So this duty can't be delayed by, trying different interventions. Well, we're going to try this or we're going to try that, or maybe assigning the student to a particular teacher and seeing how the student does with this teacher. So all of those different types of things can't delay this duty to identify all students in their area if they qualify under this definition for Section 504. So if any employee, not just the teacher, if any employee or any parent even suspects that a student's disability is hindering their education experience, or they suspect that they may need to be served under Section 504, they should submit a Section 504 referral to their Section 504 coordinator. And we're going to talk about how to locate that coordinator later on. So, but the referral itself is just the duty to identify and locate. It doesn't necessarily automatically mean that the team is going to say that the student qualifies. It's just to start an evaluation and start the consideration that maybe the student should be served. As we see here, students with disabilities, well, let's back up. Here is a representation of all the students in the school. So some of the students do not qualify for services under Section 504 or IDEA, and that's represented in the green section. So those students who do not qualify should still be supported by the school district through other means, but just not necessarily they'll gain the protections of Section 504 or IDEA. So those are the students who don't meet this definition, but they still have disabilities in the school. Also, we can see here in the purple section where students who are served under IDEA with an IEP, those students also get the protections of Section 504 with the yellow circle circling them. They get their IDEA services as well as the protections of Section 504. So let's discuss the Section 504 team. So the team determines if the student meets that definition. Team members must be knowledgeable of the student, and that's directly from the statute. They must be knowledgeable of the evaluation data that they're looking at. And they must be knowledgeable of the different placement and service options that are available to the student. The team should include typically the Section 504 coordinator in that school, as well as the student's teachers, but not necessarily all of the students' teachers, let's say if they're in high school or middle school, but they should include the teachers since they are the most familiar with if their educational experience is comparable in quality to other students in that classroom. So it should include teachers, and it may even include the counselor or the school nurse, depending on the type of data that they are looking at and seeing if the student is needing these types of services. The parents are not the official members of the Section 504 team, but they are key sources of data about the student. So they are not official members, but they are very integral to the Section 504 process to make sure that the student is receiving the most individualized supports that the school can provide. So they should be invited to the meetings, and the team should do their very best to make sure that they can schedule at a time when the parents can attend. So let's discuss the initial evaluation and any subsequent evaluation. So Section 504 describes that the evaluation must include a variety of data sources. So what the parent is observing at home and their suggestions are very important because those are pieces of data that the school may themselves not be privy to because it's at home. So it may be helpful for a parent to provide, if they're willing, any information such as how frequent are their migraines, or how often will they be out for medical appointments in a typical week, or how often do they grow distracted when they're completing homework at home. Data collection from the parent isn't necessarily required, but it can be helpful to the team, just like data collection from a teacher as far as how often the student is needing to go to the bathroom or needing to go to the nurse or needing redirection because they're getting distracted, which would be a good source of evidence for the team to consider when they're all coming together. So, also, a variety of data sources could include the medical diagnosis. So we were talking about a medical diagnosis isn't required, but it is a key source of information about the student, similarly to doctors' recommendations. So doctors themselves can't prescribe educational supports like they can prescribe medications. So they can't prescribe educational supports because they're not educators, but they definitely can make recommendations to educators. And when doctors' recommendations are provided to the team, they should consider those as well. Data sources, as we all know, can include grades and discipline reports and attendance records and test scores, everything that's locally housed at the school. So let's talk about when that evaluation should occur. Well, once the parent has given their consent to the initial evaluation, and the parent consent for the initial evaluation is suggested by OCR as required. It's not stated in the statute that they have to have parental consent, but OCR strongly requires that occur and that be obtained before that initial evaluation takes place. Now, the federal statute does not provide a deadline either for when the evaluation needs to be completed. But OCR does suggest that it be a reasonable amount of time from when the referral is submitted for the student. So let's say if the referral is submitted and it takes several weeks, that it has to be reasonable. And most oftentimes schools follow their IDEA timeline, which does give a deadline of 60 days. But it's not required, but anything beyond 60 days would probably be found as unreasonable. So a reevaluation must also occur if there is a significant change in the student's placement. An example of a change of student's placement could be a suspension of more than 10 days. That means that they've been out of school for 10 or more days, and that's probably a change in placement. And we need to reevaluate to make sure that we're providing accurate supports for the student to make sure that they're being successful. A periodic reevaluation usually occurs every 3 years. Let's say the student isn't being suspended for 10 or more days, but usually occurs every 3 years. They reevaluate to make sure that the supports are aligned with most recent data, and it's not 4-year-old data or 5-year-old data. So usually schools do a full reevaluation of every student every 3 years. But as we said, that's not necessarily within the Section 504 statute, but it does need to occur. A periodic reevaluation does need to occur. So what should the conversation look like in the Section 504 team meetings? Well, during the very first Section 504 meeting, the team should ask the first question, based on the data that we've pulled together and that we're looking at, does the student have that physical or a mental impairment that substantially limits a major life activity? And if this answer is no, then the team should document their analysis, document why they came to that decision, and then there's no need to answer the other 2 questions. Also, before we move on to the second and third questions, also this first question is very important if the student if they're thinking about exiting the student from Section 504, or they're thinking that the student no longer needs services under Section 504, then they need to go back to this first question again. Does the student have or no longer have a physical or mental impairment that substantially limits a major life activity? So the team will answer questions 2 and 3 if the answer is yes to question 1. So they should identify the skills and areas that need to be supported and then align those with the accommodations that are listed in the plan. So often when Section 504 teams meet, they immediately jump to question 3, what accommodations and supports does the student need? And maybe not necessarily asking, does the student even meet the definition of disability in Section 504? Or not asking, well, what are the areas that they are weak in? What are the challenges that we're seeing? That way we can make sure that the supports that we're providing are directly aligned to what we are needing to impact. So how often should this team meet to discuss the student's progress is a great question. So Section 504 does not specifically mention how often that the plan should be reviewed, just that there be a review process. So we suggest here in the Equity Center that it depends on each student. So for some students whose plans are working well, the team might not need to review it as often as others, but the expectation that they do meet if the plan needs to be changed or if the interventions are not working, that they do meet as many times as they need to throughout the year. Typically, schools do a review every year because they're either entering a new grade level or a new building, or they're either exiting a grade level or a building. So they usually do it in the beginning of the year or the end of the year, but it can occur more often than that, depending on how effective and how well the plan is going. So if a school is, let's say they're exiting a student from services under IDEA, and they're now going to be supporting that student under Section 504. Well, in their evaluation, so the team would have to come together, the 504 team, and evaluate the student. So in that evaluation, they should be looking at data to see if those previous interventions are no longer needed or no longer helpful or supportive to the student. So whatever changes that we're making to remove something from the plan or add something to the plan, we should always be asking, well, what does the data say? And so that's another big takeaway. Whatever's in the plan or being removed from the plan, make sure we're making sure that it's data-based and that we have some evidence or the teacher observations or the parent observations to say why we're making that change. So let's think about the letter A in FAPE. So what does the word appropriate mean? Remember, FAPE was free and appropriate public education. So what does appropriate really mean? Most people initially think about an appropriate plan, and that's definitely true. The plan needs to be appropriate, but what about appropriate protections? Section 504 has a lot of protections, and we're going to talk about those right now. So students served under Section 504 become a protected class of individuals. and they're afforded protections, and they're known as procedural safeguards. These protections or safeguards act as a safety net to prevent disability-based discrimination from occurring. So they assure that the student's school experiences are fair and they're appropriate and they're comparable in quality to students without disabilities. These processes and safeguards make sure that they protect the rights of those students and the parents of those students. So the Section 504 plan is an example of a procedural safeguard, and much of what we're going to be discussing in this presentation about the evaluation and their duty, all of those are examples of procedural safeguards that are embedded in the statute. Now, this is important to note because some students will only need the protections and safeguards of Section 504. Some students will not need an actual written plan to be served under Section 504 because Section 504 is full of protections and safeguards and internal controls to make sure that things are available to the student if they should need them in the future. So a student without a written plan, for example, can still receive the evaluation. They can still gain access to the grievance process. The parent still have access to their records to review them. And we can see those listed here, the impartial hearing. So unlike IDEA, Section 504 doesn't entitle those eligible students to services, but provides this safety net, and it doesn't expand the rights of those students, but it protects the rights to make sure that they have access just like all of the students without disabilities have access. Also, an IEP requires student goals in their plans and in their transition plans. So Section 504 teams may determine that those things aren't necessarily required for the student to receive FAPE, to have those student goals or to have a transition plan, which is required in the IDEA statute. So let's talk about the plan. Some of the students will need this plan. And the plan lists those targeted and intentional actions that are aligned to their need that provided to the student. So thinking of Section 504 plan as a district individualized policy between that district and that student. So an individualized policy are usually worded very specifically. How oftentimes do we see a policy that's broadly stated or generally stated? Not very often. So when we're thinking about plans, think about it in a way that it's an individualized policy for that student to support that student. And we're going to go a little deeper in that. So supports and accommodations that are listed in the plan should be worded very specifically so that everyone is clear, including educators and parents, on how those supports should be implemented. So if the supports for a specific subject only, like maybe math, then it should be worded in the plan as such. If it's only for a time frame, so 1 day a week or visiting with the counselor 2 days a week or after school, it should be worded in the plan as such very specifically. Even if it's for virtual remote learning settings only and not for face-to-face learning, then it should state for the virtual environment only. So they should be worded in the plan very specifically. And for example, if these plans follow the students often, and so if the student goes to another grade level and they have different teachers, can those teachers still understand what the accommodations are and how they should be implemented? So that's why it's very helpful to make sure that the plans are very specifically stated. Here, often there are questions about should modifications or can modifications be included in a Section 504 plan, or is it just accommodations? Well, here in the resource guide, it often mentions modifications throughout the guide. And so we wanted to make sure we put language from OCR about how modifications can be included in the plan. And this would be a good one to go to page 5 and read the context of this, because it talks about even if the student earns good grades, we just mentioned that. So, but modifications can be included in the plan. Plans do not only have to address learning or academics, but they can include behavior accommodations or modifications, anxiety supports, or even food-related accommodations. So thinking back to a major life activity, it wasn't just learning, it could be a variety of major life activities, and so could be accommodations. Here we see listed in the statute itself, it talks about related services and what related services might look like, because those can be included in the plan as well. Section 504 could include physical or occupational therapy, speech therapy, or counseling. It has here related services as developmental, corrective, and other supportive services. So those can be included in the Section 504 plan as well. It can also include transportation, specialized transportation services. And this is from the frequently asked questions of OCR. And so that's another good source of information. So for a comprehensive list of possible accommodations, the Equity Assistance Center in our guide, we have a section called Sample Root Causes and Accommodations. So if we're looking for maybe some targeted interventions based, let's say the student is having transition issues, or let's say the student is needing to be more organized, we have a pretty detailed, comprehensive guide of just sample accommodations that align to specific areas of what a student might need. And that link to that guide is there on pages 51 through 59. So also here, remember we're talking about an individualized policy between the school and the student. Well, the plan can list exceptions to school policies. So these policies may have a discriminatory effect on the student with a disability if they don't have exceptions available to them. And so here we see a commissioner memo from the Department of Education. Pretty much it describes that parents can petition or make the attendance policies the petition must be made before the student accumulates the number of absences allowed under the policy and allow for exceptions as necessary to IEP or 504 plans. So we recognize, and the department recognizes, that IEPs and 504 plans can be exceptions to the school district's attendance policies, but also makeup policies can have exceptions to makeup policies, but it needs to be written in the plan very specifically. So rather than to say the student will have an exception to the attendance policy, it should say something to the point of the student will have an additional 2 days of unexcused or excused absences, or the student will have additional 10 tardies or 5 tardies. So whatever the student is needing, to make sure that it's specifically worded that way, it's not broadly exception to the full policy. Or maybe they need additional, maybe 2 more days of makeup to make up work. So here we see references to the educational setting. So the statute itself does not specifically refer least restrictive environment, but a Section 514 can include changes in the educational setting within that plan. So the statute mentions that the student should be in the regular education environment as much as possible with aids and supports and services. And they, in order to be shifted from that regular educational environment, only when those the education can't be achieved with those supplementary aids and services. So it doesn't necessarily have the language of least restrictive environment, but it does say that the students do need to be in the regular educational environment as much as possible with aids and services. But examples of a change in environment that could be placed in a Section 504 plan could be a separate space, maybe a separate testing space, or homebound services, or also being assigned to the alternative learning environment. But a good takeaway is that plans should be data-based, and they have to be developed by a team of educators, and they should be specifically written to target a student need. And of course, they need to be consistently implemented. And if they aren't consistently implemented, we're going to talk about avenues for how we can resolve that as well. So here, in the context of a school, there are multiple, on occasion, or varying individualized plans that support students. And we can see them here on the right side of the screen. So if a student is served under IDEA, and we talked about how those students also gain the protections of Section 504, A 504 plan and 504 meetings are not necessarily required, because an IEP meeting is sufficient, and an IEP is sufficient to supporting the student. There's not necessarily a requirement to have a separate 504 plan or a 504 meeting, but just know that they do gain those protections as well. Now, we do recommend that if a student is being served on a 504 plan, and let's say they do have an individualized health plan through the nurse, that those teams come together with the nurse and with the 504 team, and they assess if maybe those plans need to be attached, and they need to at least come to the consideration of yes or no, they should be attached, or those same accommodations in the behavior plan need to be go ahead and included in the 504 plan or attached in some way. Either do it that route, or make sure that every time they adjust the individualized health plan, or every time that the behavior plan is adjusted, make sure that those teams come together and meet. Every time that the 504 plan is adjusted, make sure that those other teams who are working on those other plans, that they come together and meet every time. If they're not going to attach the plans together or include them, at least come together to make sure that there's not any overlap or miscommunication or any conflict, or if there's a counseling plan. So making sure that those teams either come together or make sure that they either attach them together to make sure that everybody's on the same page about what's included. So a parent may deny the school from implementing the full Section 504 plan. So even after they consented to the initial evaluation, they can deny placement or implementation of the plan. And the schools should get this denial of consent in writing to make sure that everyone's understanding what's being stated. So let's say a parent disagrees with either one or a portion of the accommodations in the plan that let's say it's just one of a few things that they're not agreeing with that needs to be included. So the parent can either deny the full plan, or they can seek resolution using a due process, which I said we're going to talk about in a second. But they can either deny the full plan if they don't like one portion of it, or seek resolution in due process. But the Section 504 plan can't be cherry picked for implementation. So let's just say, well, a teacher says, I want to do this accommodation, but I don't think the student needs this accommodation. So it can't be cherry picked by the educator or the parent, because it's the team of individuals that came together, that looked at the data and determined this individualized policy. And so that it's going to be the school district that's going to be held accountable what's included in the plan and what's not included in the plan. So it's very important that what the team comes together and develops, that it's fully implemented. So let's discuss costs. So Section 504 requires the local school district to pay for services to make the education accessible to students with disabilities, just the same as they pay for services for students without disabilities. Because the educational system is legally liable, just like the airports and public libraries, to make sure that they're accessible to individuals with disabilities. It is the school system who must comply with Section 504, just like the libraries and the airports. So the cost must be free to parents. Unlike IDEA, there's no federal funding that's provided to the states under Section 504. And unlike IDEA, Medicaid will not pay for services under Section 504. Typically, the funding comes from the general education budget in the school system. So regarding not putting something in the plan because of cost, and we can see a quote there from OCR. They state that school districts must make these type of decisions based on the student need, or based on the concern, and not based on the concerns about the cost or providing that support. So, and this is from the resource guide as well. So it is a concern for them as well as us that individuals aren't including items in the plan because of the cost. And we always relate people back to this from OCR, that it's based on the student's need and not necessarily about the cost of providing the support. Here, let's talk about post-secondary experiences. So institutions who are colleges or universities that receive federal financial assistance, so that's very important, they must receive that assistance. They must still comply with Section 504 as well as privacy rights under FERPA. But here, the difference here is post-secondary is not required to provide FAPE. So, and the frequently asked questions of OCR goes into more detail about what is required for universities and colleges under Section 504, but FAPE, the free and appropriate public education, is not required in colleges and universities. So high school Section 504 plans may not travel to college with the student. And what we would advise is individuals reach out to those universities or colleges that we're thinking about and see what kind of supports and services do they provide to individuals with disabilities, and to speak to those departments about what college education may look like for their student. But in regards to dual enrollment, so districts who have high school students that are enrolled in college courses or university courses, those districts and those Section 504 teams that are still supporting those students but are responsible for FAPE for those students. So that team should assess and provide those needed supports, and it could look like them seeking the college level aids and services and pretty much being a liaison, making sure that they are putting those the student with those necessary services that the college does provide, because the district and the charter is still responsible for FAPE for those students that take those college classes. So that doesn't just release and say, well, it's if you don't submit your assignments on time, then you need to speak with the professor. Well, you have that team has to be a liaison, and they have to put in their plan how they're going to be supporting the student while they're taking those classes. So let's talk about student behavior and the discipline of students served under Section 504. And this quote is from OCR's Highlights newsletter, and they stated that a student cannot be punished or disciplined for behavior that is caused by a manifestation of their disabilities. So the Section 504 doesn't specifically state the term manifestation determination, but OCR does suggest that the first item to consider is whether the conduct was caused by the student's disability. And we can see there in question 1. Also, the other two questions are very important as well, that the team should consider if the plan was adequate. Was the student's needs adequately met to prevent or to prevent the student from from that misconduct? Also, was the plan implemented? Maybe they had a great plan and great supports, but it wasn't implemented in the incident that led to the misconduct. So all three of those questions are very important, and the team should meet and come together to make sure that those questions are deeply considered before instituting the student code of conduct. And here's further. So let's say the student misbehavior is the result or a manifestation of their disability. Well, the students should be supported and addressed through intervention. So the school can intervene by aiding the students' understanding of their challenges and helping that student identify what their triggers are and how they can self-mitigate in the school environment. So having those interventions in place rather than just applying the code of conduct, if it was a manifestation of their disability, then they would have to respond with interventions and not be discriminatory by applying the code of conduct because it was due to the disability. And in some instances, a reevaluation may have to occur to determine the root cause of the behavior, to make sure that the student is really being supported and to prevent future instances. So if the conduct was not the result of the disability, let's say they had those questions and the plan was implemented and the plan was adequate and it was not the result of the disability, then the school can apply the code of conduct that's approved by their school board and implement the appropriate consequences for the offense. So the Office for Civil Rights considers the following requiring reevaluation. So an out of school suspension of more than 10 consecutive school days requires reevaluation. So if the student has been out of school suspended for more than 10 days or more, then the school needs to go ahead and do a reevaluation to make sure that the student is being supported and not being discriminated against. Now, let's say that there is a series of separate out of school suspensions. So let's say there's a day of one suspension and then a 2-day suspension, 3-day suspension, and let's say it all totaling of more than 10 days. Then that also as well would require reevaluation, especially if that creates a pattern of removal. So a pattern of removal is referring to the difference between if it's 1 day here, 1 day here, 1 day here, is totaling up 10, or if it's 4 days here, 3 days here, on and on, totaling up 10. That kind of is the spectrum of a pattern of removal if they're consistently removing the student. But both of those will require a reevaluation under OCR for Section 504. So what might discrimination look like under Section 504? Well, if we go back to the intent and the purpose of the law, discrimination is when a student is excluded from participation in or denied the benefits of an education due to a disability. So when any of the protections that we discussed here are not in place, and then the result of the student's loss of access to an education that's provided to all of the students is what discrimination might look like. And we're always often stating that we're technical assistants and we're not legal advice. So to get more detail on what this is, because the legal definition may include references to the term deliberate indifference and intentionality of the school district. But if you really want to know what discrimination might look like in Section 504, contact an attorney. But this is what our response would be, is to always go back to the initial intent and the purpose of the law and the protections and the student's loss of access to everything that's afforded to a student without a disability. Now, to say all of that, it's not to say that the student cannot earn bad grades or that the student cannot fail. So just like their peers, there's no guarantee that they're going to get all A's and all B's. And a student can be retained under Section 504, but if the team is carefully considering the data and they're developing a targeted plan and implementing that plan, student failure and student bad grades should be very less likely. So let's discuss the due process. We mentioned that several times. So if a parent or even a teacher feels that the plan isn't adequate or the plan is not being fully implemented, they have several routes of due process, and we're going to discuss those here. They're called the Grievance Procedures for Section 504, as well as an Impartial Hearing procedures. And these are the two safeguards that are directly described in the statute. So if a parent feels that their student is being discriminated against, or maybe they should be served under Section 504 and the team said that they don't meet the eligibility definition, they could file a formal complaint, and that's called a grievance, with the district or the charter. And so by law, every school district has to have their own grievance procedures. And these procedures must be prompt, and they must be equitable, they must be fair. And we'll show you how to reach out to the coordinator to gain this information on what your district's grievance procedures are. But also a parent can request an impartial hearing. So a hearing is presided over by an impartial hearing officer. And this is in the statute. And so this person has to be knowledgeable of the Section 504 law, and they're impartial, so they can't be employed by the district, and they can't be representing the district or the charter. So this officer has the authority to issue subpoenas, they can administer an oath, they can examine witnesses, and they can define the issues that you're going to be discussing. And they can determine the way that the evidence is presented. So it sounds a lot like how a judge may, or a legal judge or a mediator may provide support, but their decision, the decision of this impartial hearing officer, is binding. So it's binding to all parties. Everyone must implement it once it's been made. immediately. So those are the avenues that are available to parents that are within the district themselves. And here's how to seek out your coordinator, so that way you can request, if you would like to read your grievance procedures or your impartial hearing procedures in your district, to seek out your Section 504 coordinator. Maybe if you want to submit a referral for a student to see if they meet that definition of disability in Section 504. So locate your Section 504 coordinator. You can look at either your district's website, or you can go to the department's website. It's called the School Personnel Directory. If you put in ADE School Personnel Directory in Google, you may easily find it. But here's a link when you get this PowerPoint. And then here's a screenshot of how to search. And pretty much when you're looking and you're searching, the title is going to be Section 504 Coordinator. And it'll have the rehabilitation law right next to it when you're searching. And then it'll have their email and their contact information listed there. But we talked about grievance procedures and impartial hearing procedures, but here are some external resolution avenues that are also available to parents. So a parent can submit a complaint here with the Equity Assistance Center if they're feeling that they've been discriminated against or the plan's not implemented. So what we do here in the Equity Center is we guide school districts and we guide charters in their compliance. We review what they're doing, and we say, well, that's not a good idea. Maybe the team should look at this and have these thoughts, but y'all have this documentation and evidence. And so we kind of our co-thinkers with them to make sure that they're in compliance. But if a parent or anyone wants to submit a complaint, we have a complaint form. And here on this slide, that's a link to our complaint form that can be submitted. And if you don't want to submit a form, individuals can call up here and just gain guidance if they don't want to do a formal complaint route. We definitely get a lot of calls from parents to provide assistance as well. Also, another external resolution avenue is for the Office for Civil Rights. They also accept complaints. And they maintain, honestly, the ultimate responsibility of enforcing Section 504. So they provide assistance to school districts as well. They sometimes provide on-site investigations and making sure that they're in compliance and have evidence if they are found out of compliance, that they have evidence that they are changing their practices. And then another resolution is to file a complaint with the federal court. So, and seek legal advice if that's a route you'd like to take there as well. And that's kind of the recap of my piece. Next is Mr. Dillingham, and I'm gonna mute myself so that way we can hear him clearly.
Thank you. The Equity Center is very appreciative of the fact that I'm trying to get the fact that we were given this opportunity to share with you our responsibility. Your state legislators implemented a statute 610-111 that created the Equity Assistance Center to assist school districts in meeting their civil rights responsibilities. Ms. Johnson has covered so much until I don't want to repeat, but there are some things I'd like to say to you in regards to how you can help us help school districts and how we can help you help us help school districts. Knowing the law, knowing the responsibility of the school district is an advantage if you don't use it as a disadvantage. Now, we've shared with you some things in regards to the school district's responsibility. We are very aware of the school district's responsibility and the law. That's our responsibility. That's what we do, technical assistance. So when you hear that we are technical assistants, that means we have very little power, but we have a lot of knowledge, a lot of understanding, and a lot of information to share with the school districts in regards to their responsibility to comply with the law. Now, responsibility comes first. Uh, uh, who's responsible? Now, I see parents are responsible. School district has the responsibility by law, but by success of the school district serving your child, success of the school district identifying your child, you as a parent, you have a responsibility. When you sometimes fail to meet your responsibility, you lose your rights. I want to repeat that. Sometimes when you fail to meet your responsibility, you may lose your rights. So your rights and your responsibility in terms of why we are even talking with you today is because you have a child in the school and the school has a responsibility. But the parent also have a responsibility. And if you allowed me to place the responsibility in priority, I would say you would probably be the first person that I would say has a responsibility. You know your child better than anyone else. You knew your child before your child started school. So you know your child. So you have a responsibility. Now, don't let knowing your child give you the impression that your child will never do something or your child can always do something. You know your child at home. And the knowledge I'm speaking of in terms of you knowing your child, you probably know more about your child's learning style and what to expect of your child than the school will ever know. You that's your child. He spends a lot of time at school, but he also spends a lot of time at home. And it's your responsibility to be certain that the school district understand your child as much as possible. Ms. Lasagna has already stated that a team will make a decision, but it's important. And I'm going to say it this way, it's your responsibility to attend the meeting. The team meeting is your responsibility. So many times parents say, well, if I'm not a part of the team and I can't make any decision, then what's the purpose of me attending? You are a resource for the team. They need you there. Your child needs you there. If I were on the team, one of the first things I would probably ask you is, how did your child learn to tie a shoe? Or something to that nature that I know you taught your child. Someone taught him before he began school. So I would then get something in regards to the student's learning style. Were you able to just explain to him how to tie a shoe? Did you tie a shoe and then tie it to a certain point and then let him tie it or her tie it? Or did you stand next to him or sit next to him and tie your shoe and have him to watch you tie? I'm going to stop there and say, I know you understand what I'm saying, but it's your responsibility to be able to say to the team, these are some of the things that I know about my son that in regards to developing a 504 plan, I would request, not require, because you can't require, I would request that this be considered in the plan. Now, we talk to the school districts and they know there are not many school districts that have not had an opportunity to understand the law and the responsibility. In regards to your child and the school, the District 504 coordinator should be your guardian, your child's guardian angel, the one that you communicate with. Yes, the teachers, the principal, but the guardian angel for your child and the district meeting its responsibility should be the 504 coordinator. Some school districts will have one. Some school districts will have one in each building, each grade level. So the configuration of how they comply with the law is fairly flexible. But with your responsibility, I want to share with you some things in some ways that you can better communicate with the school. You can get benefit from all of the responsibilities that the school district must comply with in the law, and your child will benefit from the requirements of the law. Ms. Johnson has explained to you that the team will meet to evaluate and determine if your child qualifies. If you get this letter from the school district and the school district has set a date, it is your responsibility to read that letter and then contact the school district and either say, I will be there, or you contact the school district and say, can we change this to a different date? Because it is almost impossible, or it is impossible for me to be there on this date. And you would need to be there to represent a resource for the committee in regards to your child. Again, I say, who was the first teacher? Who understands your child's learning style more than you? It is your responsibility to be certain that when the plan is developed, that you have a copy of that plan. And not only that you have a copy, but it is your responsibility to understand the plan. If you are not quite sure of the language, in education, we use a lot of acronyms, and there are reference to programs and lessons that ordinarily lay people, and I'm not lowering that, but they don't understand. I've been with the department for some time, been in education for forever, and I have to go back and look up some of the acronyms that we use from time to time. So the first thing in regards to a notice that your child is going to be referred or has been referred for an evaluation is for you do the very best you can to be there. And then once you're there, to be a resource to the team. Then to understand the decision that the team made. The responsibility of the school district is for your child to receive a quality education. So in reviewing the plan, you want to feel pretty comfortable that you understand that this is not an opportunity for your child not to apply himself or herself, not to apply themselves, not to master skills, not to prepare to move to the next grade level. So the next responsibility would be for you to ask the question, how can I help? The law is protecting your child. The school district is developing a plan. Now, where do I fit in as a parent? So it is your responsibility to inquire about how do I fit in to this plan that's going to assist my child so that my child will be successful and master the skills and have all of the opportunities that the school has to offer for students that attend the school. It may be the least or it may be the greatest responsibility, but it's your responsibility to have a good working relationship, to help create a good working relationship between the school and your child. I would say make a little note. That I would say try it and see. Say to the team, I'm trusting that I can trust you. Be sure you give them your faith in them so that you can hold them accountable and being truthful with you. You may never agree with all that in the plan, but you certainly want to understand. A couple of more suggestions, and I know our time is limited. Am I out of time, Lasagna?
Well, yeah, it's 11:03, but you can wrap it up with a few more words if that's okay with
Just
you.
a few things I would like to say to you. It's important for us to help the school, and most often, very important for us to help you and your child receive what is due in regards to compliance with the law. If when you contact us, you have followed a procedure, and there is a procedure by which you should follow before you contact the Equity Assistance Center for enforcement help, not knowledgeable help, but enforcement help. Parents, get something. Develop a diary, and you keep a diary of phone calls, communication, resources, anything that you do in regards to your child's education in 504 accommodations. When you contact the Equity Center, you put in your diary that you contacted the Equity Center, who you spoke with, and what you spoke with them about or regarding, what advice they gave you. The Office for Civil Rights say, in most instances, if there is no documentation, it didn't happen. So, and when I say a diary, I don't mean word for word, but we'd like to know when you contacted the school district. The next slide. Some of the indicators for parents, the next slide, some of the indicators for parent are the same indicators that for parents are the same indicators that schools are to be aware of. And I would say under suspensions or expulsions, don't wait until your child is about to be suspended or expelled from school, even though the law protects them from being expelled from school if in fact there has been no consideration, there's not been a manifestation determination that the disability was or was not the reason why the student violated the policy. But all of these indicators are indicators that you should be conscious of in regards to referring your child, letting the 504 coordinator know that I believe my child may or should be evaluated for 504 accommodation. We're here to provide technical assistance so that every child in the school in Arkansas with a disability that affects learning and performing will have an equal opportunity to benefit from what the school is providing to students with no disability. My time is up.
But oh, what good information. Good information from both presenters. The Center for Exceptional Family greatly appreciates your willingness to collaborate with us and provide this information to our parents and professionals in our state. I have not received any questions. And so obviously, again, your information was really good. They got it all with what you gave them. I did note that the executive director for the Center for Exceptional Families did post in the chat that TCFEF can provide individuals with tabs to go in a notebook, kind of like where Mr. Dillingham was going in regards to a diary. But TCFEF will be happy to provide tabs for the parents. If you'll give a shout out to Ms. Shelby, she provided her email address on there, then she'll get those out to you. This meeting, webinar, has been recorded, and it will be on the Center for Exceptional Families website, tcfef.org, in a few days or so. In the meantime, feel free to go by our website, check it out. Also visit us on Facebook. And Mr. Dillingham and Miss Lasagna, thank you so much. We greatly appreciate your wisdom and your time. And Mr. Levere, thanks for making a presence for us. We're going to sign off now. Feel free to contact TCFEF if you have any questions, and we'll be happy to work with you and make the connections that you learned about here today. Goodbye.
We appreciate you contacting us, and we're here to serve.
Thank you. I feel that, and I thank you very much. I hear it and I feel it. Bye-bye, everybody.
Bye-bye.